Welcome to Faculty View from CWRU. My name is Julia Aromatorio, and I'm a 3L student and the co-president of Case Western's chapter of Law Students for Reproductive Justice. And I'm here today with Associate Dean Jessie Hill, who's an expert in constitutional law and reproductive rights law specifically. Dean Hill litigates, consults, and writes frequently in the area of reproductive rights, and she will be submitting an amicus brief in the case of Whole Women's Health v. Cole. And many people are saying that Whole Women's Health v. Cole is the most important abortion case to be brought before the Supreme Court since Planned Parenthood v. Casey in 1992. So can you tell me a little bit about the case?
Sure. So the case involves a challenge to a Texas abortion law, and the law has two main provisions that are at issue here. One requires abortion clinics to meet the standards of ambulatory surgical facilities, which basically means they have to have meet certain requirements pertaining to the physical plant, staffing, parking, things like that. The other part of the law requires doctors performing abortions to have admitting privileges at a local hospital. And both of these requirements can be really hard for clinics to meet. And usually when a state passes requirements like this pertaining to building standards, they'll either give older buildings a chance of getting a waiver or to be grandfathered in or something like that. And here in this case, abortion clinics cannot get the advantage of grandfathering or waivers or anything like that. The admitting privileges requirement can also be really hard to meet because there can be a lot of resistance to granting admitting privileges among hospitals, granting them to abortion providers, either because of resistance to, opposition to abortion, or because the hospitals are Catholic, for example, and they can't do that consistent with their directives. So that can be also a very, very difficult requirement to meet. Hospitals can grant or deny privileges for any reason, pretty much, or no reason whatsoever. So, and in fact, the effects that this law has had on abortion access in Texas have been really severe. So before the law was passed, there were 40 abortion clinics in Texas, and after part of the law went into effect, that law closed down about half of those clinics. So now there are about 20, and it's expected that if the law goes fully into effect, there'll be 50% fewer than that even. So 10 or maybe even as few as 7.
Mm-hmm. And so why is the case considered to be so significant?
Well, it's significant because, as we just talked about, first of all, the impact is really important. And these sorts of requirements, admitting privileges requirements, ambulatory surgical center requirements, and things like this are becoming increasingly common. But the other reason why the case is really important is because it's the first chance that the Supreme Court has had to reconsider the undue burden standard from Planned Parenthood v. Casey since that case. So the Supreme Court has decided a couple of other abortion cases since 1992, a handful of cases, but none of them have really presented head-on this question of what does undue burden mean, how should the standard be applied? And that's a standard that really has created a lot of confusion and brought about a lot of criticism in the lower courts.
Sure. So what exactly is the court being asked to decide in this case?
Well, so the court is being asked to decide whether these two laws impose an undue burden. And there are basically two theories at work here, two reasons why it might be an undue burden. One of them is just the fact, like I mentioned, the really severe impact of the law. So can you leave a state the size of Texas with only 7 abortion clinics, right? It has a major impact on women's ability to access this, constitutionally protected, safe, and legal service. So if the law goes fully into effect, the entire Rio Grande Valley of Texas, which is remote and impoverished, will be without a single provider, and women in that area would have to travel hundreds of miles round trip. So that's one theory, that it's an undue burden simply because it reduces access so severely. The other theory is that this kind of law imposes an undue burden because it obstructs access to abortion without actually providing any offsetting medical benefits. So the evidence in the case really strongly suggests that there's no real safety benefit to having these sorts of requirements, admitting privileges, ambulatory surgical center requirements. abortion is already one of the safest surgeries around, basically. So, the argument is that the burden is undue in the sense that it's unwarranted, right? It's not, it's unnecessary.
Sure. But if the state claims that the law has health and safety benefits, don't the courts usually give deference to the state on that point?
That's a really good point, and that is definitely an issue that's lurking in this case. So the answer is, yes. In a lot of circumstances, courts will defer to states' view of the safety and medical benefits of a particular law. Here, I think it's a little different because the evidence is so one-sided. It really, almost every court that has looked at the evidence has said that there's basically no safety rationale here. And just to give you an idea, in this case, the state of Texas said if women were concerned about accessing abortion, some of the women would be able to go out of state to New Mexico, where there are clinics in El Paso if they want to access abortion. Well, New Mexico doesn't have any of these safety regulations in place. It doesn't have these admitting privileges requirements and so on. So it definitely undermines the idea that these laws are necessary for health and safety if the state itself is telling women to go out of state. So in this case, I think given the one-sided nature of the evidence, I think there's a good chance that the court will really take a hard look at it, and considering also that there's a constitutional right at stake here.
Right. So do you have any predictions about how the case is going to turn out?
Well, it's always a little risky to make predictions about what the Supreme Court is going to do. I think if I had to say, I would guess that the Supreme Court is going to strike down the Texas law as unconstitutional. It seems pretty likely this is going to be one of those 5-4 cases with Justice Kennedy as the swing vote. But Kennedy was one of the authors of the joint opinion in Planned Parenthood v. Casey. And so he was one of the creators of the undue burden standard. And I think if he wants that standard to have any sort of staying power, if it's going to mean anything, I think he's going to have to vote to strike down this law and find that this one does constitute an undue burden.
Well, we can hope so, but guess we'll have to wait and see. So thank you for speaking with me today.
Sure, thank you.